And CBS News legal analyst Rikki Klieman joins us now on the phone. Rikki, there's all this surveillance video, there are all these text messages, and still the judge says, no, not enough evidence for this even to go to trial on the most serious charges. Did that surprise you, and what's the explanation for that?
Yes, it initially surprised me a great deal, because I think that many of us who had looked at the case believed that it was one arc of an action, that it began with the gauntlet of the hazing, it continued through the night, and it ended up with indifference to a young man who was obviously by morning in grave condition. However, when you look at it over time of the day and understand what good lawyering can do, what you see are defense lawyers really led by the relentless, fierce Ted Simon, making a point, which is to say, you cannot look at this as one arc, as one total joint venture. You have to look at each defendant and look at his responsibility, if any. And what they did in painstaking detail in probably one of the longest preliminary hearings that I have seen over a 7-day period, which spread over months, is what they did was they took the Commonwealth's own evidence and they showed individually, well, he ran a gauntlet of 4 stations, but say, for example, my person was at the wine station, there's no evidence that Tim Piazza had wine. Or my person is at the beer pong station, and there's no evidence that he drank more than a bit of the beer and then handed it back. So what they did was they said individuals are only responsible for their actions, and beyond that, at the end of the gauntlet, when Tim Piazza, according to the defense, and obviously according to the judge, after the gauntlet, when Tim Piazza went into the basement for the social drinking, the thesis of the defense was that Tim Piazza then drank voluntarily. I think this is a disappointing decision, obviously, to the prosecution and to the Piazza family, who has conducted themselves with such integrity. And yet it is not even a joyful moment for the defense. It's a moment of relief, but they still realize that someone died.
Yeah, disappointment for the district attorney, the prosecutors, and the Piazza family. The district attorney said she will try to reinstate the involuntary manslaughter charges as well as the aggravated assault charges. How does that work, and do you think those efforts will be successful?
In the Commonwealth of Pennsylvania, when you have a magistrate like this one who hears evidence and comes up with a decision, the prosecution has the right to go to a higher court and have a judge look again at what the situation is. So this prosecutor will petition that judge to say, wait a minute, judge, the judge below, the magistrate, did find that these defendants should go forward on the charge of reckless endangerment. But then the judge decided not to go forward with the charges of aggravated assault and involuntary manslaughter. And aren't they basically all the same thing? So isn't the judge's decision inconsistent? And so that's what the prosecution will try to show a higher judge. Now, will the prosecution be successful is quite another matter. You will have the prosecution petition the judge. You will have the defense attorneys again object vociferously, and then the judge can make a decision and say, look, the magistrate below heard evidence full and thoroughly for over 7 days. So why should I then say that that judge is wrong and then start the process all over again? But we will see. There is a question about that finding of recklessness when you do have recklessness plus death equaling involuntary manslaughter.
Do precedents of other similar cases tell us anything about how this all might shake out?
Well, we know that there have been hazing deaths for not only tens of years, but over 100 years. We know that they're documented. All you have to go do is look at Wikipedia, and you will see them. But what we find in recent years is that there finally have been prosecutions that have had some success. We know that Virginia State, for example, had convictions for hazing deaths. We know that in Baruch College that you ultimately had convictions, whether by plea of guilty or by trial. So this is not the first case. I think that this is the case that created the most attention because you wound up with so many defendants being charged, and you had video surveillance, which is a very, very rare thing. So I think that there have been precedents before, obviously not precedents that mean that this case has to go forward, but that will certainly not stop other prosecutors in other states from going forward with hazing prosecutions all the way up to a manslaughter charge.
And Rikki, as this case goes forward on the lesser charges of reckless endangerment, unlawful hazing, violating liquor laws, will there be a jury trial, and what do you think would be the timeline for that?
Well, on the lesser charges, we're going to have to wait, of course, to see, because they're wanting to try these defendants together. We're going to have to wait to see what happens when the prosecutor petitions on the greater charges to see if those greater charges will be heard again. But regardless, ultimately, these cases will either go forward to a jury trial or they will end in a guilty plea. These charges are not, the lesser charges we know, are not going away. Whether or not with the passage of time a plea bargain could be worked out, or whether or not the defense says, look, we really think that the same evidence applies throughout, that we are not going to have our clients plead to a reckless endangerment, be it a 2-year misdemeanor versus a 20-year felony like aggravated assault, that decision is going to be months, if not a year, in the making.
Okay, a very sad case. Even the defense attorney today saying this is no day for celebration for anyone. Rikki Klieman, thanks for walking us through it.
Thank you.